right, folks, one more video that's dealing with civil liberties. And this, again, is going to be dealing with the rights of the accused. And bear with me, I do have a restless cat tonight, so she may jump around or flash in front of the screen really, really quick. Like I'll try and keep a straight face as she does. But as we keep going tonight and we wrap up these last parts, the Fifth Amendment is actually one of the most important amendments for our purposes. Now, blow this up maybe just a skosh bit more. The Fifth Amendment, and I'm sure that you've heard of this before. I'm sure that you've heard of people say, you know what, I plead the Fifth, for example. And really what we're saying with the Fifth Amendment is you've actually got a situation where it prohibits you from self-incrimination. Okay, so you cannot be asked questions, or you are not required to answer questions where you would incriminate or witness against yourself. That's the thing that oftentimes we're actually, most conditioned to. The idea of due process and fairness in court, the idea of no self-incrimination. But on page 151, it gets into some other things here. And you'll notice it says in italics, and this is the first italic section on 151, it says no person shall be held to answer for a capital or otherwise infamous crime unless on indictment of a grand jury. Now, understand, when we think of juries, oftentimes we're probably thinking of juries more in state and local cases. And we're thinking about juries that are actually going to make a decision upon innocence or guilt. A grand jury under the Fifth Amendment is actually not going to deal with that at all, but rather it's just going to deal with the idea that there is enough evidence to take something to court. That's all it is. Pretty straightforward and pretty quick. Now, double jeopardy. Double jeopardy, and this is the second italicized piece on here. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. In other words, you can't be charged. You can't be tried for the exact same thing more than one time. If you are found innocent or found guilty, there could be an appeal to be sure, but this is still part of that same case. And if it's done at the one level, say state level or federal level, it's possible that you could leave that level and go to a different court, and you could bring on charges of the same variety. But the bottom line is that if you go to federal court or you go to state court and win, well, they can't come back and try and get you again. That's what double jeopardy ultimately is. So understand on this, double jeopardy is prohibited. Now, the text mentions O.J. Simpson, and like I was saying, there are some exceptions to this. Exceptions in the sense of, hey, there might be a crime at the state level, and the exact same crime could be at the federal level. And if you are tried in federal court because of a particular crime and ultimately you are not convicted, it is not crazy that you could be tried at the federal level. Okay, so it's two different courts that you're dealing with there, but they couldn't just come back with the same charge again. Okay, so kind of keep that thought in mind. I mentioned OJ to you. This is another exception. In the United States, we have criminal court, criminal cases, and we have civil court, or we have civil cases. Now, in a criminal situation, O.J. Simpson was actually charged with murder, right? Cutting off the head of his wife, his ex-wife, and her lover. And it was a pretty graphic case when this happened. Now, I bring this up to you. He ultimately was acquitted. He was not found guilty. But in a criminal case, this is the state or the government going after, prosecuting someone. And the piece that's at issue would be your freedom, meaning you might have to go to jail if you were to lose, or in fact, your life if this would have been a death penalty kind of a crime. Now, in civil court, it's a little bit different. In civil court, it's not about the freedom. And in civil court, it's not about your life, but rather it's about your money. In civil court, it's not the government that's involved this time, but rather it is an individual suing another individual for monetary damages. if there is a car accident and someone is injured, well, there's probably going to be a traffic ticket that's been issued. But then after that traffic case, there's going to be a civil case where the issue is not going to be about points on your license or jail time. It's going to be about civil damages, money to pay for the injury, say, that somebody suffered. And in OJ's case, he was acquitted criminally, but in fact, he lost in civil court. And you're probably saying, well, how can that be? Well, because in criminal court, you're talking about your life and your freedom, the system is going to require the highest level of proof to take that away. Well, when you go to court, they're not going to view your monetary standing as strongly. And so the level or the standard of proof is much lower. So maybe there wasn't enough proof to get the criminal conviction. Maybe, in fact, there was enough proof to gain that civil judgment and to be able to gain some money, out of this for the crimes that were committed. So understand on this, that's what we're talking about. And there are exceptions, but the same issue in the same level of court doesn't happen. You can maybe reopen a case, you could appeal a case, but you can't start over again with a brand new case. And then this last thing down here is actually Miranda warnings. And the cat really wants to get in front of this computer screen right now. But I'm sure that y'all have heard of Miranda before. The idea that you have certain rights that the police are going to have to ultimately notify you of before, in fact, they really begin to question you. I'm going to run a quick video here, and bear with me as I juggle my screens for just a second. This video is actually going to be dealing with the Miranda warnings. It's just a couple of minutes, and hopefully this will help you understand a little bit about this. Here we go.
What if I told you the words, "You have the right to remain silent," didn't come from a cop drama, but from a real Supreme Court case that changed how the police operate in America? In 1963, a man named Ernesto Miranda was arrested in Phoenix, Arizona for kidnapping and assault. After 2 hours of police interrogation, without a lawyer, he signed a confession. That confession was used to convict him, but there was a problem. He had never been told he had the right to remain silent or the right to an attorney. His legal team argued that his confession should be thrown out because he wasn't properly informed of his rights. The case made its way to the U.S. Supreme Court, which had been growing more focused on protecting individual rights during the Warren Court era. In a 5-4 decision, the court ruled in favor of Miranda. They said that the Fifth Amendment protects against self-incrimination, and that means suspects must be clearly informed of their rights before being questioned. From that point forward, police officers across the country were required to recite what became known as the Miranda warning. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If these rights aren't read, any statements made may not be used in court. Here's the twist. Ernesto Miranda, after being released due to the overturned conviction, he was later retried without the confession and still found guilty. Yet his name lives on, not because of what he did, but because his case reshaped American justice. Miranda v. Arizona reminds us that even people accused of crimes have rights worth protecting.
I give this to you, and again, I've mentioned this a couple of times now, but it bears repeating again here. The trick when you think about going to court is that it's not necessarily primarily about the rights of the people that were victims of crimes. I think Kitty has given me a photobomb right now. But in fact, if you look at this, what you're going to end up seeing is it's actually the rights of the accused that are a little bit more important. So understand as we get going with this tonight, that in fact, the court, this is just precious, isn't it? Understand that the court is going to be trying to ultimately protect the rights of the defendants for fairness, because they would much rather free a lot of guilty people than in fact ever imprison someone who is innocent. That's what we're talking about. Now, let me go back to the outline, maybe mercifully, because we're going to try and get this wrapped up. And I'll jump to the Sixth Amendment and the idea of the right to counsel. And you heard that in there. You have the right to an attorney. It makes mention of. And I give this to you because now let me stress this right was originally set up to be a right to counsel in a capital crime like a murder case. It has since been set up so that you have a right to counsel if there is a felony. Now, I suspect that maybe some of y'all have gotten speeding tickets or misdemeanor charges or different things like this. You are not guaranteed the right to counsel there because your freedom is not at issue or your life isn't at issue. Just like when we were kind of talking about the idea of the civil case versus the criminal case, the standard for an attorney is going to be a lot easier to get if your freedom or your life is in fact on the line. So that's what we're talking about here. Now, one last thing for this tonight, and that's actually going to take us to this idea of the death penalty. You know, cruel and unusual punishment. And this is actually the Eighth Amendment that we're talking about this time. I told you she was going to do this. You know, when you think about cruel and unusual punishment, the death penalty is the issue that almost always comes up under the Eighth Amendment. And here's the thing. Now, I got to be honest with you. If you were going to tell me that I was facing the death penalty, I was going to be killed, sounds like cruel and unusual punishment, doesn't it? Sound like cruel and unusual punishment. The idea that you're going to die. Well, here's the thing, and this is the way that this works. Basically, the way that it's viewed is that if you are given the death penalty, it's cruel and unusual if, in fact, you're going to feel the pain. Now, I want you to think about some of the historical ways that, in fact, people have been given the death penalty. You know, in some countries, they'll bury you so that the only thing that's showing is your head, and then they'll run elephants through there. And if you're lucky, the elephant gets a clean shot right on your head and you die pretty much instantaneous. But if they just happen to swipe a piece of you and crush part of you, well, you know, there's a problem. Or the idea of being stoned. This is something that seems a little bit biblical, right? I used to think that stoning was kind of like dodgeball. You know, people are throwing stones at you. You're going to be able to run for a while. Sooner or later, you're going to get tired. They're going to hit you, and then it's going to become painful. Well, it's also like that with stoning. They bury you very high, and in fact, they start throwing these stones. It's not like you have the ability to be able to avoid it. You're just going to keep getting pelted with stone after stone after stone. You think about Jesus. You know, Jesus was an execution, right? Crucifixion. And how is it that people die in crucifixion? Now, this is going to sound weird the way that I say this, but if it's done right, y'all, they're going to die from dehydration. And if they die from dehydration, that means that they're going to have been hanging up there for a while. So understand when you think about this, these are things that are really painful and you're really conscious of. Even hanging, you know, if hanging is done right, your neck snaps and you die instantaneously. But if your neck doesn't snap, that means you're choking. And if you're choking, you're going to be conscious that you're dying. What makes the death penalty not cruel and unusual is theoretically if you don't feel pain. So think about something like a lethal injection. If you're given a lethal injection and the chemicals are given to you appropriately, then at that point, you know, your body is basically going to be shut down by the chemicals, but you're going to die a largely peaceful death, and it's going to be really quick. Let's say that you were to go to the gas chamber. Well, in theory, you're going to die in your sleep. And I've heard a lot of people say, man, when I go, I would really like to go in my sleep so I don't know exactly what's happening. Now, the trick on this is that if you don't feel pain, then the sense is that it's not cruel and unusual punishment under the Eighth Amendment. Now, you'll see a number of debates out there because it's funny, the United States is really the only developed country that still practices the death penalty. And some of the places that we bought the chemicals, when they began to realize kind of how we're using them, they decided not to sell us these chemicals anymore, which now means that states came up with their own means for the death penalty. And now all of a sudden it didn't work nearly as smooth, meaning people were actually feeling the pain. So understand, if you don't feel pain in the context of an execution, that's one thing. If you do, that makes it illegal under the Eighth Amendment. And some states still have, laws on the books that say that they could be hung, they could be put before a firing squad. You get the idea on this. Now, I bring this up to you because they do this. Sometimes people that have been given the death penalty, they get to choose the method. And in order to embarrass the state, they will pick one of these older methods just with the idea in mind. Here we are in the 2000s and you're still shooting people. What the hell? That's what they'll do. Now, in the last couple of years, there was a new example that popped up of an unusual punishment. I don't know if y'all had seen this before, but it's the idea of the homeless. I don't know if y'all had seen this, but there were several cases that came up, and this was towards the end of COVID, maybe, where homeless people were setting up their communities, right? And they were setting up their communities maybe just a little bit too close, a little bit too close to where businesses and gathering places were in a city. And so the city began to write the homeless people tickets, and they didn't want them living, gathering in these places. Now, y'all, here's the thing on this. Now, it seems, at least in bad taste, that you're going to write somebody homeless a ticket for finding a place to live. Albeit, if I was a business owner, I don't know that I would want a community of homeless folks living outside the parking lot, where my business was located. Now, with that being said, the homeless folks got some attorneys and they began to sue. And they said that it was cruel and unusual punishment to be given tickets for living illegally when in fact they didn't have any actual place to live. The case went before the Supreme Court. The Supreme Court threw it out. They decided that they weren't going to extend cruel and unusual punishments beyond this. But now you see a renewed focus by cities so that they can avoid certainly this bad publicity. They're actually renewing their efforts to create more accommodation for homeless people within the context of city services and city budgets. Not everybody's in favor of this, but it's just the idea they haven't extended cruel and unusual punishment to the targeting of homeless with city citations and fines that they cannot pay anyway. Y'all, I'm going to have to give somebody some attention, so I'm going to cut it here. I will pick up with some more videos a little later. Bye, y'all.